Hello and welcome back again. Now it's time for a seminar on competition policy and labor markets. There are two reasons for this focus. The first is that there's a fast-growing interest in this topic among policymakers in the US and also in the EU. But also in Sweden, we are very unfamiliar with this concept of thinking of competition policy in terms of labor markets. We are therefore very honored that Professor Joanna Marinescu will give a digital speech for 30 to 35 minutes on this topic and then participate in the discussion. Apart from being a professor, Joanna has served as a principal economist at the US Department of Justice, the Antitrust Division, and for 2 years. And she has testified before the US Congress on these issues. But before I leave the floor to Joanna, I will just say a practical thing, and that is we shorten this session with 15 minutes, so we end up 3:30 because of Anna Stansbury is sick, so the other session will be shorter due to that. So in order to synchronize the sessions, we also reduce the time frame for this seminar. But for Joanna, this doesn't make any difference for you, but we adjust here in Stockholm. So after having said this, Professor Marinescu, Joanna, the floor is yours.
Hi, everybody. Good afternoon. I'm very glad to be here. So I'm going to talk to you about competition in labor markets from research to policy. So I'm going to start with the research insights and what we have learned from the literature, the academic literature in economics on this topic, and then move on to policy. So in terms of research, and this comes from a chapter in the Handbook of Labor Economics that I wrote with Jose Azar, you can think that there are three reasons for imperfect competition or monopsony power in the labor market. The first one is oligopsony, and that's the first row in the table. And what happens there is that unlike the perfectly competitive model where you have an infinite number of firms or employers competing for workers, here you have a finite number of employers, so just a few employers. And because they are finite, they are able to interact strategically in the labor market. And why are firms paying less according to this model? Because there's a finite labor supply elasticity to the market. So what does that mean? It means that if the firms can coordinate with each other implicitly, and I'm not saying there's necessarily collusion. Again, this is coordination because of a limited number of employers. They are able to pay workers less because workers care about working in this market. Let's say nurses in the Stockholm area, they want to work in nursing in Stockholm. So if all of the hospitals, let's say, are aware of that and there's a limited number, they're able to pay nurses less because they're not going to easily go work elsewhere in a different city or a different kind of job. And that's what this finite labor supply elasticity is about. Even if you underpay people, they don't immediately leave and go to another job. So there is room for employers, if there's a limited number of them, so less competition, to pay people less than their marginal revenue product of labor, or what they should be paid in a competitive market. So how do we measure imperfect competition or market power under that model? A key measure is labor market concentration, which is essentially related to the number of employers, but weighted by shares. So even if there's many employers, if a couple of employers have a humongous share of all jobs, that would still lead to high concentration. And then, of course, the labor supply elasticity to the market. So again, if you think, say, nurses in the Stockholm area, how sensitive are they to wages? If the average wage of nurses in Stockholm area in all jobs goes down, how likely are the nurses to go take some other jobs, either outside nursing or in a different city? All right, so that's the first reason, again, limited number of firms. Second reason for imperfect competition in the labor market is the idea of differentiated jobs. And now we're looking at the second row in the table. And so there, the fundamental reason is heterogeneous preferences. And so there could be infinitely many firms, but firms are different and workers care. And a key example of this that turns out to be very important empirically is simply distance. Workers prefer jobs that are close to home. So even if there's many jobs, those that are close to home are better for the worker, and therefore the worker is willing to be paid less in order to work at a job that is nearer to their home. And so then, therefore, the reason why firms pay less in this model is because the job, the reference job that we're considering is better than the next best alternative for the worker, for example, because the job is closer to home. So what matters in this model, how do we measure market power? You have to think about the job substitutability from the point of view of workers. So how similar are jobs to each other? If they're very similar, there's a lot of competition, not much market power. But if jobs are perceived to be very unique from the workers' point of view, then this is a source of monopsony power for firms who can pay workers less. Additionally, you can complexify this model by adding other elements from other models, including the first type I told you about, like labor market concentration and the labor supply elasticity to the market. So therefore, that's the second reason. The third reason why you have monopsony power or imperfect competition in the labor market is search and matching. So in this model, there could again be infinitely many firms and they might all be identical. So there's no difference among the firms, but there are search frictions. So what this means is that workers cannot meet all jobs immediately. Boom. Instead, you're meeting maybe one job at a time, deciding if you're taking it. And if you decide to say, no, I'm not taking this job, it will take a while before you can have another offer that you can consider. And for this reason, these frictions, as you can see intuitively, it makes it so that employers do not aggressively immediately compete with each other. Instead, the worker is going to be willing to accept a lower wage in order to avoid having to go back and search again, which has uncertainty with respect to how long it's going to take for them to find another suitable offer. So what matters in this context to measure employer power or monopsony power, the outside option. So that is, what would the worker get if they didn't get a job? Traditionally, we think of things like unemployment insurance benefits. So the higher they are, the less market power employers have. And the shape of the matching function. So, how easy is it for workers and jobs to meet each other, the bargaining power of the workers, and you can also add in there labor market concentration in a more complex version of the model where you add also an element of concentration. So that's the overview. So therefore, three different reasons why you can have monopsony power. So then, if you think about monopsony power, and I already previewed that, but we define it in our review of the literature as the markdown. We say that this is the key way to think about it, which is the difference between workers' marginal revenue product, which is the impact of the worker on the revenue of the firm. So if you add this worker, how much more revenue does the firm make? Or you could think about worker productivity, right? So that's the first element. And then we are comparing productivity, to put it as a shorthand, and the wage. And if productivity is above the wage, there is a gap, and that gap, that's the markdown. So that's the gap. And specifically, we use the measure of the gap divided by the wage. So it's a percent. As a percent of the wage, what's the gap? So that's the markdown. So in a perfectly competitive market where there's infinitely many firms, they're all identical to each other, there's no frictions, you find that wage is equal to the marginal revenue product of labor, or there is no gap between productivity and the wage. The workers are paid all the way up to productivity. And that's because, again, intuitively, in a competitive market, employers are competing really hard against each other. So if any employer were paying less than productivity, the worker could immediately switch to an employer that's willing to pay the worker all the way up to their productivity. So if we look at the empirical literature across many studies, they find that the markdown is between 15% and 50%. So what does this mean? If all other things equal, if you could eliminate all sorts of employer market power, monopsony power, wages would increase somewhere between 15% and 50%. So that kind of gives you an idea of the magnitude. And I want to note that this is an upper bound because some sources of monopsony power, like, for example, different job differentiation, are not really feasible to eliminate. Jobs naturally are at different distances from workers' home, and it's difficult to completely eliminate that. Of course, you can make better transportation, maybe you can work remotely. So there are things you can do, but eliminating all relevant differences between jobs is likely unfeasible and also not necessarily something you would want to do because workers actually like those elements of the job, that they appreciate, and that's why they're willing to get paid less. So again, nevertheless, quantitatively, if you could eliminate all sorts of monopsony power, wages would increase between 15% and 50%. So now let's think about policy elements. And this is from another review of literature that I wrote with Jose Azar in the annual review of economics, also from 2024. And here we are listing, all the policy areas that are relevant to monopsony power. And we classify them into three categories: antitrust, barriers to switching, and direct interventions to increase job quality. And some key policies that we'll talk about today are mergers. So I'm going to tell you a little bit what has been done in this area in the US. I'll also mention no poaching and wage fixing, but on mergers we have the most empirical evidence. And then I'll talk a little bit about non-compete agreements, which are to preview agreements between the worker and the employer. This non-compete agreement says that the worker, when they leave the company, cannot work for a competitor, usually for a certain period of time after they leave the job. So it could be 6 months or something like that. So that's the non-compete agreement. And then in the last category is direct interventions to increase job quality. And I know that today we're talking about unions. I'm not going to say much in the talk right here because I want to focus on antitrust, but unions are one of the ways how you can counteract monopsony power by helping to boost wages of workers. And of course, the minimum wage is another such tool where you can increase wages. And this last category of policies do not directly implicate competition. It's not competition policy. Rather, it's a way to boost wages that might be reduced by lack of competition. And if we think that, we really want to do something about wages, then you can directly intervene through the minimum wage, for example, or through boosting unionization. So this was an overview. There are many policies that you can look at through the lens of labor market competition. Now I want to shift to specifically antitrust and policy and telling you about my work as the principal economist at the Department of Justice Antitrust Division, which I was there for 2 years between July 2022 and June 2024. So I just finished that work just a year ago now. So before I got there, the Biden administration has really focused on competition and competition in labor markets in particular. So this executive order 14036 was called Promoting Competition in the American Economy in 2021. And one of the things it said is that we need to do more to understand competition in labor markets and promote greater competition in labor markets. So Tim Wu, at the time, who was a law professor, was Biden administration's National Economic Council special assistant for technology and competition policy. And in the executive order, it was required that the administration write a report about the state of competition in the labor market, and Tim Wu and his team work on this report. So as part of their information gathering, they reached out to me and interviewed me due to my labor antitrust expertise. And eventually, through this contact with the administration, eventually I joined the Department of Justice Antitrust Division in July 2022 as a principal economist, where I was directing a team of about 40 PhD economists in doing the economic analysis that is behind the cases of the Department of Justice. And so in this role, I was overseeing the economic analysis of all casework, including recently, you probably heard about the Google search case and the Google ad tech. So I worked a lot on the Google ad tech case, for example. But of course, because of my academic background, I was especially interested in labor cases as part of my broad portfolio. So let me tell you a little bit about some of the labor cases that happened while I was there. So first off, there was the Bertelsmann publisher merger case. So in 2022, the DOJ Antitrust Division successfully won the Bertelsmann merger case for the first time only based on labor monopsony. So the idea here was that these two publishers, Penguin and Simon and Schuster, they wanted to merge. They were two of the top 5 publishers for best-selling or top-selling books. So the argument that we made at the division was that if these two big publishers would merge, this would decrease authors' pay. Authors would have fewer opportunities of publishers to work with, and this would contribute to decreasing competition between publishers, ultimately reducing authors' pay. And so we marshaled evidence to show that, and the judge, ruled in favor of the Department of Justice. And if you want to know more about this case, we discuss it in an article from 2024. The second thing that happened while I was at the Department of Justice is that we worked on an overhaul of the merger guidelines, ultimately leading to the 2023 merger guidelines. And here I want to emphasize labor in the merger guidelines. So first, what are the merger guidelines? The merger guidelines are a document that's put out by the antitrust agencies of the US, so the Department of Justice and the Federal Trade Commission. And the goal is to inform the public, practitioners, firms, and the courts about what the agencies, the antitrust agencies, consider when reviewing or challenging a merger. So in other terms, from the point of view of the antitrust agencies, what is an anti-competitive merger? So these guidelines are updated regularly, but not on a fixed schedule. So, the duration between updates can vary. But since 1982, interestingly, these merger guidelines have mentioned competition among buyers without specifically mentioning employers, but they were talking about competition between buyers. And, just as an aside, another interesting case that I've also been quite interested in is agriculture. So often smaller producers, smaller farmers are selling to big business their production, and that too is potentially a case of monopsony power over the farmers because they're big buyers and small farmers. But for what interests us here, employers are the buyers of labor services. And so finally, in the 2023 merger guidelines, we have one whole guideline, Guideline 10, that is devoted to discussing competition in labor markets. And again, you can read more about the details in that article that we published in 2024. So what was the goal of this guideline? As I said, the idea of competition among buyers was already there, but we wanted to reflect just the research that I told you about right before. So there was a lot of economic learning showing that many labor markets are highly concentrated, that such concentration, is negatively correlated with wages, and that labor markets have specific characteristics that can make them especially narrow, including high switching costs and search frictions. So again, this was all about incorporating some of what we've learned about labor markets within the merger enforcement guidelines. And from a policy standpoint, a critical point from the guidelines was that the agency said they will evaluate the impact on labor as a standalone basis to challenge a transaction. So this is really important. It means that if there is a problem in the labor market, if a proposed merger is likely to significantly, decrease competition in the labor market, just like the publisher merger that I mentioned to you right before, that is enough of a reason for the merger to be challenged and potentially blocked if the judge decides to block it. So in other terms, and this is really important in the antitrust community, you don't need to also show, let's say, that the consumers are going to be adversely affected by the merger. If you can show that the workers are, likely to be adversely affected in terms of anti-competitive effects, that's enough to block the merger. So now let me talk to you about some additional cases that are non-mergers. I told you about mergers. What else? So one important area of enforcement is against wage fixing and no poaching in the US. So, in general, in US antitrust law, there are criminal cases where people who are found guilty can go to prison for this, there's two big categories: price fixing and bid rigging, and market allocation. So, what does that translate to for the labor market? Wage fixing is an example of price fixing, so employers fixing wages. And no poach, which no poach means when two employers agree with each other not to hire each other's employees. So that's called no poaching agreement. And no poach is an example of so-called market allocation. So what does that mean? An example of no poach, for example, could be, oh, there are two large companies in the US. Let's say they have business in Philadelphia and Chicago, and they could agree that, in Chicago, the one firm is going to be able to hire, and in Philadelphia, the other firm is able to hire. So that's a market allocation just straight up. But in the case of no poach specifically, it just means your workers are yours, my workers are mine. Don't touch my workers, right? So in that sense, the specific form of market allocation that's linked to the identity of the employer. So again, no poaching agreement. Two firms agree not to hire each other as employees, which means that they're essentially saying, my employees are mine, yours are yours, and we're not going to compete over these employees. That's why it's market allocation. So generally in the US, this conduct is called a per se violation of the antitrust laws, and it's a felony, it's a crime under the Sherman Act. And the enforcement against this kind of behavior is growing rapidly across the world in many jurisdictions that have moved to enforce against wage fixing and no poaching agreements, which it seems like are much more common than we thought before we went and tried to dig up evidence about this. And so precisely, I want to tell you about a story, one specific case that we worked on at the DOJ that involves no poaching and wage fixing. So there was this healthcare company called VDA. It pled guilty in a conspiracy to fix wages of Nevada school nurses and to restrict their mobility. So what happened there is that VDA, there were two big companies that were providing contract nurses to schools in that area, the Clark County School District. And VDA, for one of its employees, participated in a conspiracy with the other contract healthcare staffing firm to suppress wages, so to keep wages low and to eliminate competition by agreeing to allocate nurses and fix the wages of these nurses. So essentially, they agreed to keep wages low and to not compete with each other for these nurses. And so VDA was sentenced to pay a criminal fine of $62,000 and restitutions of $72,000 to victim nurses who, because of this agreement, ended up making lower wages. And here the fines are, just to note, there's a calculation that's based on 20% of the total volume of commerce, which here is the total wage bill that was affected by this conspiracy. And this case was the antitrust division's first successful enforcement action in a no poach case. So I think it's a really interesting story, especially because we know from the research that nursing labor markets are especially subject to employer power. So here's another interesting case, which is no poach in the franchise context. So many companies, including McDonald's, have a central company, and then there are establishments that are franchisees. So each of the McDonald's establishments, some of them belong to the main company McDonald's, but most of them in the US are franchisees. So they belong to a entrepreneur who's a franchisee and who licenses from McDonald's. So in this particular case, it turns out that there were no poach provisions where one McDonald's agreed with the other McDonald's, again, not to hire each other's employees, or at least to consult each other before hiring employees. And so it was there was a court case about this. One of the employees complained. They found out and they complained that this led to a lack of opportunity, that they couldn't be hired by a different McDonald's who was willing to actually pay them a higher wage. But then when the new employer found out that this worker was already working for McDonald's, they said like, oh, no, we can't do this because we can't, compete with another McDonald's. So essentially what happened there is that the first level court ruled against the plaintiff, against the worker, saying this is fine, the companies can do this. But then there was an appeal, and the antitrust division, joined by the Federal Trade Commission, filed an amicus brief in this appeal to say that the plaintiff was correct, that this was a problem in terms of suppressing competition in the labor market. And ultimately, on appeal, there was this decision called Deslandes, that's the name of the plaintiff, who was a woman working at McDonald's. And importantly, the appeal court noted that no poach clauses, again, these agreements between two competing employers not to hire each other's workers, are horizontal agreements in the labor market, and they can be per se illegal. It can be a crime to engage in this agreement. And the appeal court said that the district court, the low level court, was wrong to allow consumer benefits to justify detriments to workers. So, they said you can't just say, oh, well, this way workers are going to get paid less, so consumers get to pay less for their hamburgers. That's just not a valid legal argument. And so the judges said the antitrust laws prohibit monopsonies just as they prohibit monopolies. And so therefore, they said that the defendants, the companies, had to bear the burden of showing that these no poach clauses don't actually run counter to the antitrust laws. So this was a very important decision to establish the legal status of no poach clauses, including even within a franchise context, that different franchisees compete with each other for workers, and therefore these no poach clauses can be illegal. And then the last thing I want to tell you about as far as policy enforcement actions is that recently the DOJ and FTC released these guidelines for employers about things that might be illegal from the point of view of the antitrust laws. So if you look at this list, this is a tweet that I sent, and the first points, 1 and 2, concern the agreements between companies not to recruit, solicit, or hire workers. So this is called broadly no poaching agreements. So, this is what we just said from the competitors, or to fix wages or terms of employment. So terms of employment are also potentially included. So for example, if we agree that we each pay the same bonus to the workers, that's similar to fixing wages. And so points 1 and 2 say that those can be expose companies to criminal liability, and the point 2 says that this is also the case in the franchise context, which I just explained for McDonald's. Then point three says that exchanging competitively sensitive information with companies that compete for workers may violate the antitrust law. So in other terms, if I'm an employer and I talk to my fellow employer and we're hiring in the same labor market, we're competing for workers, and we are, for example, telling each other how much we pay, how much we intend to pay, that's called competitively sensitive information. And if found out, could be a violation of the antitrust laws. Then fourth, if there are agreements that restrict workers from leaving their job, this could violate the antitrust laws. For example, non-competition agreements, which I described before, agreements between a worker and the company they're working for, where the worker is not allowed to work for a competitor after they leave the job. And finally, there could be yet other, types of agreements where workers' mobility and ability to get higher wages could be impaired due to lack of competition, and those too could violate the antitrust laws. So now, while I was there were some important aspects that just didn't work, and I think it's important to say that so you understand the policy process. The first thing is that the Federal Trade Commission, which is the other agency, not the one I was working for. We have two big competition agencies in the US. They wanted to ban non-competition agreements. So again, these are the agreements between the firm and the worker, where the worker says they want to work for a competitor. And for now, this new rule by the FTC is held up in court. So the court said that, essentially the key argument is that the agency, the FTC, doesn't have the power to issue such a significant rule without congressional authorization. It's so-called the major questions doctrine. So they're saying that if they want to do a rule that's so major, they need to go back and pass a law that explicitly says this. So that's for the non-competition agreements. By the way, that doesn't mean that you couldn't sue a company for unreasonable non-competition agreements. I just want to note that. But as far as a rule that bans them always, that for now hasn't gone through. Then the second point, which is to the right of my slide, is the inclusion of the Hart-Scott-Rodino, the inclusion of labor in the Hart-Scott-Rodino merger filing requirements. And so what you need to know is that for every merger that is above some minimal threshold, companies need to send their paperwork to the FTC and the DOJ, so the antitrust agencies, in order for the agencies to say whether they want to look at this transaction as potentially anti-competitive. And the agencies have 30 days to start an investigation if they decide that the transaction might be anti-competitive. So these HSR forms were updated in 2024, requiring all sorts of new information. But initially, in the proposed rules, there was a requirement to provide information on workers. But in the end, this was abandoned because the companies said that it was too much burden on the companies to provide this information. So how much time do I have? Because I wasn't watching.
Now, a few minutes.
Okay, so we're good. I'm almost done. So this was under the Biden administration. Now what happens under Trump? So interestingly, antitrust, including labor antitrust, is an area of relative continuity between Biden and Trump. So for example, the new head of the antitrust at DOJ, this was an interview by Congress and Gail Slater, and she said that there are clear through lines from the tenure of AAG Del Rahim, who was Trump 1, Cantor, who was my boss at the division under Biden, and the antitrust policy of this administration, that is Trump 2. On issues such as the first thing she mentions is the importance of protecting workers, which is quite interesting. So that's for the DOJ antitrust division. At the Federal Trade Commission, which remember is the other big antitrust agency in the US, the chair, Andrew Ferguson, who succeeded Lina Khan, whom you might have heard about, he announced that number one, the 2023 merger guidelines are in effect. So therefore, this includes the labor portion of the guidelines. And that there will be a joint labor task force at the FTC that will continue to specifically focus on, labor issues, low labor competition issues for antitrust. So therefore, as a takeaway, you have a menu of policies that I focused on antitrust policies that include enforcing against wage fixing, no poaching, anti-competitive mergers, and also overly broad non-competition agreements. But there are other tools in the toolbox like minimum wages and bolstering unions. That these two tools do not directly increase competition, but rather address wages that might be too low because of a lack of competition. So I'm coming to my conclusion. Monopsony power is real, it's measurable, it's policy relevant. So first, we've seen that there's finite labor supply elasticities to the market. You have market concentration, you have job differentiation, and search frictions. And because of those reasons, you have monopsony power. Then if you look at the empirical evidence, there's robust empirical evidence across sectors, settings, and time. And in the end, we find that across whole literature, wages would increase between 15% and 50% if monopsony power could be completely eliminated. Then policy matters. So you can increase competition in labor markets and therefore bolster wages and working conditions for workers by enforcing against anti-competitive mergers. We have a new guideline that's devoted to that for mergers, regulating non-competition agreements, and as again, alternatively, you could use other tools like minimum wages or union support. So, and finally, to conclude, in terms of perspectives, this area of antitrust is increasingly popular internationally, and also in the US, there is continuity across administration. So, labor antitrust has both bipartisan roots and momentum in the US. Thank you very much.
Thank you, thank you. Uh, just a few short questions before we leave the word to the panel. Sorry, I have problems with the panel with the mic.
I can hear you for what it's worth.
Oh, okay, okay. The first question is, could this policy changes in the merger guidelines and everything be possible without the research, or is it research, has it been necessary?
I think the research was important because it lends credibility to the policy push. But I don't think research is always strictly necessary depending on political forces, right? As we all know, sometimes certain things have wind behind them, and then you can do them. But I think in this case there was a combination of a concern, I think, across many rich countries that over time it seemed like there was a growing gap perhaps between wages and productivity, especially for the median worker. So big concern about the state of the labor market, what's going on. And then this research showed one particular problem in the labor market that could be addressed with policy. And so, of course, this seemed like something that politicians would want to use if they wanted to address problems in the labor market. So in other terms, we found a particular angle where something could be fixed and improved for workers.
Okay. Are you surprised that the policy seems to be stuck, be kept with the Trump 2 administration, although this bipartisan history?
Yeah, so I was a little surprised, but not as surprised as that because I actually talked to Make and Del Rahim, who was the head of antitrust at the DOJ under Trump 1, and he was very interested in these labor issues. So therefore, in that sense, this is something they did back then, and you might think that they would do it or not. But in that sense, frankly, I was rather positively surprised that this seems to be an ongoing interest from the Trump administration. Obviously, each administration is a little bit different, but relative to how many things are drastically different, this is relatively speaking something that they have more agreement on.
Okay. The last question then. Uh, I listened to a webinar you participated in a year ago where there was a person was critical about this development. Can you give the audience just a short, brief view on what the critiques might be?
It's really interesting because initially there was quite a bit of criticism that was coming from all angles. Some of it included, oh, we don't have enough evidence. Maybe this isn't really a problem. And besides, there's not enough experience from the agencies to do this, so maybe they can't, figure out how to do it in practice. And part of my role, frankly, was to establish blueprints, practical things about how you would do it. So I think by now we've a little bit moved past that. And interestingly, even among, lawyers who represent employers, surprisingly, there isn't necessarily so much antipathy to the issue because they're actually interested in the topic too. They think it's interesting. Now, of course, they're trying to say naturally they represent their clients.
Mm.
In this particular case, though, it's okay.
Okay.
But they're happy to engage in the discussion of, yes, this could be a problem, in some cases. But of course, naturally, if they're representing employers, they want to say, oh, this particular case is fine.
Mm.
But I feel like to a large extent, this is not really debated as a, or most people are on board with the general idea that competition in labor market, could be threatened by certain employer behaviors.
Mhm.
But it's more about, oh, practically speaking, is this particular case problematic or how common is it? How big is it? So I think we've moved more into these matters of degree rather than straight up denial that this is a thing.
Okay, interesting. Then we invite the panel up here. First, Johan Kreisberg, then Joachim Smedman, Arvid Fredenberg, and Wojter Swissen. And Johan Kreisberg is chief economist at the trade union Swedish Engineers. Joachim Smedman is a legal advisor at the European Trade Union Confederation. Arvid is a chief economist at the Swedish Competition Authority, outgoing chief economist. Yep.
Yes.
That was everyone. Sorry, Wojter, sorry.
I'll just go back.
The senior researcher at ETUI, the European Trade Union Institute, working on these issues. Very nice having you here. First, briefly, your general thoughts about the presentation by Ioana Marinescu. Johan Kreisberg, please.
Well, I think it's a very interesting topic, and I think we all can agree that like monopsony power in the labor market is very present. The problem is that, I mean, is that what is illegal in this context and what is not. That is the hard thing. I mean, I think from a Swedish point of view, and I think it's well, maybe all over, I mean, it's not illegal for an employer to pay less than the marginal revenue product of labor. I mean, actually, if there's a legal demand, it's if you have a limited liability company, you should maximize your profit. So if you have the ability to pay less, you should do it. And what we want to do is like, try to what Professor Marinescu was talking about is like try to avoid those things where they do well. When we talk about poaching and illegal things, that's the problem.
Okay, Arvid, from the competition policy, what are your first thoughts?
Well, thank you, Daniel, and thank you, Iona, for a insightful presentation. I think we are stepping up. I think competition policy in labor markets are increasingly important in Europe, and we see signs that we can do something, and we are interested in getting the information on these potential no-poach agreements. So if you have any, if you've heard of any, please contact us.
Yeah. Okay, let's start with that. I'll come back to that later. And Joachim, from the European Trade Union side, what do you hear from Professor Marinescu?
Thank you. I think we from the European Trade Union Confederation side very much recognize the picture painted by Marinescu in the sense that monopsony power in the labor market is real. There's a growing awareness about it, including in the trade union movement, but also national competition authorities, trickling up also to the EU level and the Commission, European Commission as the apex commission in enforcer in Europe. But still, let's say, somewhat lagging behind compared to the US. We have seen positive developments already during the last mandate of the European Commission, where there was a quite broad overview of the EU legal framework on competition in the light of sustainable development, mainly green. But from the TUC side, we're really trying to push also from the social perspective, saying that you need to look at both sides, not only the green, but also the social. Because in the end, competition policies need to serve the general interest, not only and this is of course what we need to discuss today. In whose interest is it? Only the interest of a business and consumers, or does competition policy also have a role to play for workers? And we do believe that it definitely has.
Nice. Thanks for that. Wojtek, you have written a report, actually, a research report on these topics. Can you just, in a few words, address that paper with what you have heard here?
Yes. So thank you very much for the invitation, first of all, and for being in this panel. Is this on? Yes. It's very nice to come after Professor Marinescu, who I think I find it really inspiring that you have, on the one hand, the really good research, the economic research, and then action taken as well to do something about these issues. So that I think is really important. And as you said, at ETI, we are doing some research into these issues of monopsony, concentration, and so on as well. And in this report, we looked a bit at the literature. We looked at a meta-analysis of the studies that have been out there. And I think the main thing that comes out there is that, yes, you have the same issues that you see in the US. You see them as well in Europe. The effects on wages are slightly lower, which is a bit what you'd expect, given the stronger labor market institutions we have. I mean, collective agreements, union density, that should all help support workers' bargaining positions. This is substantially stronger in Europe than in the United States. And you see that effect a bit when you compare empirical studies. So you see less impact of concentration on wages, but crucially, it is still there. So it's not like everything is fixed in Europe. And I think Joachim will know much more about this, but legally it's less on the agenda, is my impression. I mean, it's growing. There was yesterday this issue about the non-poaching agreement of Delivery Hero and Glovo. So, I mean, there is movement, there is action being taken. There's discussion on non-competes, for instance, but even there, we're lagging behind what was proposed in the US, which was a very bold move. Yeah. And we're still kind of data gathering in Europe, is my impression there.
Is this an ongoing project that is part of your everyday work now, or is it just a separate project? Or
I really wish so. It's something we really want to keep on working on.
Yeah.
And at the moment, it's an ongoing project, but a relatively small one among the other ones we have. Because we do think this is very important. And what we're trying to do in this project is also combine insights from labor law and competition law with the economic research we're doing to try and get a bit more of support for the trade unions and everyone who's trying to work to make this issue better and improve workers' outcomes. Okay. So yes, it's ongoing, but not with as many resources as we'd like.
Okay.
So if people want to work on it with us, let us know.
Thanks. Joanna, do you have any comments on what you've heard?
Yes, I just wanted to mention an interesting twist that I think it's important to kind of drum up support, including potentially among employers, because some of this conduct, you might think, oh, the employers obviously have an interest in non-enforcing, but that's not necessarily the case. And I want to take the example of non-competition agreements. So, obviously the non-competition agreement hurts the worker who cannot go to a competitor after that. But that competitor is also hurt because they want to hire this worker potentially, and now they are not able to do so. And there is a very interesting recent academic paper that came out by Xi about C-suites, so executives, and showing that for executives, despite the non-compete, the executives are able to negotiate essentially for the value so that they're not really hurt. But that the competing firms who want to hire these executives, they are really hurt and would love to hire them. So there is also a loss, not only for the workers potentially, and of course the C-suite executives are better able to defend themselves, but also for other companies who, in this instance, would want to hire the worker but are prevented from doing so.
Johan, your members, engineers, they are very valuable at the labor market. Do you know how many of your members that are under non-compete agreements, or?
No, we're actually trying to establish that right now because it's a growing number, that's for sure. I mean, and it is. I mean, if I just could, well, two of the things that are happening right now, which is connected to this monopsony power that and we don't know really, if I'm honest, to know what to do about it. Is like we've had for years in Sweden, we've had the employers saying that we want to, we want to employ, we can't find university-educated engineers, and still the wages for engineers hadn't grown faster than other groups. And one of the, I think the main reason behind that is just monopsony power, because if you compare our members to lawyers and people in business and so on, they are every one of them are working in the big cities, while our members are working in manufacturing firms throughout the country, and they don't have many employers to choose from. So what has happened the last few years is with increasing possibilities with remote work, they're working, their labor market regions have increased rapidly, and suddenly their wages are growing. But what's happening now, you have both the movement to return to office from the employers, and you have increase of competition clauses and things like that. And very hard to prove that this is a way to regain the monopsony power. You don't know that, but it's quite interesting.
Yeah, but you're working on this issue with your trade union, okay. And also Arvid, the competition authority, has also written a joint Nordic report. I guess it's the first concerning labor competition issues, no?
Yes. Last year we wrote a report on labor market, the Nordic competition authorities together. So we looked into these issues and looked into the monopsony question and we thought really hard, and we came up with the report, and we will continue to cooperate within these type of cases.
Do you have any plan for the content of this cooperation, or where are you in the process?
We are early in the process, and we're sharing techniques and ideas.
Okay.
But our focus is on agreements.
Non-competes?
No poach agreements, and wage fixing would be our primarily focus.
And why not mergers?
I'll give you 3 reasons.
Yeah.
I don't think we will block a merger on labor grounds in Sweden. If a company has monopsony power, it will, when hiring, it will probably have some market power when selling as well. So we will already look at it, and we will probably bring the case on those harms. Wages in Sweden are quite rigid downwards. So it would be hard to prove a wage reducing effect of a merger in Sweden. And thirdly, it is generally very hard to block mergers in Sweden. We typically lose in court when we try.
Okay, so legally, the practice makes it difficult.
Yes.
Okay, but then I turn the question to you, Johanna. What do you say about the arguments not focusing on the mergers here?
So I think that it's, if you, in the US as well, it's easier like from a resource perspective of the agency, if you have evidence that there was actually an agreement, it can be easier to go after that than doing a merger study, because the merger, just to, for people who are not in this world, the merger is it's something that is proposed. So you need to predict the future using all sorts of, evidence and, sophisticated analysis. So it's a lot of work. But once you establish, procedures to do it, it gets easier. So there's a lot of learning by doing. And so I would argue that part of why it's hard, it's a little bit of vicious circle. The less you do, the less you know how to do. So every time you're thinking about doing it, it's a problem. And similarly in courts, at least in the US, there's precedent. So if you never bring the case, there's no precedent. So courts don't know, it's harder for the courts to come to a clear decision. So I think part of it is kind of pushing over that hump and getting started, and eventually it gets a little bit easier to do. But I do want to pick up on one element about the labor market versus the product market harms. It's true that sometimes you have both labor market and product market harms, but in some cases, the labor market harms are actually much easier to prove because, let's say, especially for manufacturing, you mentioned engineers in manufacturing. Manufacturing markets are typically nationwide, if not, international, but the labor markets are much more local. And that's a typical case in manufacturing, for example, where a merger could really have quite a profound negative effect in a local labor market, especially in a smaller city, where the impact on the product market could potentially be quite limited due to, the competition that is much more national or even global. So I think, there are certainly reasons to consider also, especially if there's a good case that comes around, for labor, to consider doing that. And because there's so little enforcement in labor, I would argue that the marginal benefit can be quite substantial because we are starting from very little enforcement in labor for mergers.
Arvid, do you have a comment on that argument?
Yes, and I think the future is brighter than today because with the current competition law, we can only block mergers that harm competition in Sweden as a whole or in a large part of Sweden. So we cannot block local mergers, but there is a proposal for a law change. So maybe in the future we could block mergers that harm local labor markets.
Okay, thanks. Then I change the perspective a little bit here and go to you, Joachim. When you discuss with your affiliated unions, are they hot on this topic, or do you have to push them to think about these issues, or?
I would say yes and no, in the same way as we have had lengthy discussions also with the European Commission on the relevance of these topics. And I think on both sides of our interlocutors, the foot in the door was really when we developed the guidelines, the competition guidelines on collective bargaining for solo self-employed persons, where basically the Commission issued interpretative guidance to clarify that even though self-employed persons in principle qualify as undertakings for the purpose of competition law, when they engage in collective bargaining as social partners through unions with a counterpart, it is indeed collective bargaining outside the scope of competition law. Because this had been perceived as a real obstacle for our affiliates, also bearing in mind digitalization, more non-standard forms of work. And I think it's important also to bear in mind that in principle, competition and labor law have quite similar objectives. It's about addressing abusive behaviors, protecting the weak, rebalancing the power relations in a market. But since then we've moved on. We developed a study looking at avenues that already exist at EU level to also bring cases to the attention of the European Commission, be it for the purpose of state aid control, antitrust, mergers. And recently also the Commission launched a public consultation to review the merger guidelines at EU level, where they have indeed now also included questions on labor market relevance. And we will, of course, apply as DTUC and also encourage affiliates to contribute to this public consultation. So just to name a few experiences.
Yeah, thanks. Before I leave the floor for a last comment, I just want to say that we convene again at 3:45 instead of 4 in the big room, because then we have the final discussion 15 minutes earlier than predicted before. Okay. Having said that, the final comment from the four of you here, and Ioana Marinescu, can you start from the US?
Absolutely. I'm really excited to be here and learn about some of what's been happening in Europe, of which I was somewhat aware, but I'm hearing yet new things. And so I think it's very encouraging to see, how this area of policy is building up block by block across the world and across, various areas of enforcement. So I think this is, from my perspective, really encouraging. Thank you.
Thanks. Okay, Wojter, your turn. Final word.
Can they be two final words?
Yeah, sure.
Thanks very much again. I just want to highlight, because Joanna mentioned the impact also on the companies who want to hire people of this things like non-competes, that of course it goes wider than just the workers. There's the issue on the companies, but there's also the issue on society as a whole, because there's a limiting effect on innovation and therefore productivity. So, I mean, yes, we need to protect the workers, but it goes beyond that. It's also just about a good function of the market. And then about the non-competes, which I think is also very interesting, because they do tend to hit the more highly skilled workers more, like engineers. And I know in Finland, which I'm going to assume is exactly the same as Sweden.
Won't be sure.
No, it must be. It's in the north. So there was Akava did a survey, and they found about 37% of their high-skilled members had some sort of non-competes. In the Netherlands, it's ranged between 20 and 40%. And of course, there are some reason for these sort of agreements, like training, like trade secrets. But generally, people tend to go outside of their remit, and they tend to not be justified so well. So I think that's also quite an important thing to look at. It would be very interesting to know more.
Thanks.
Thanks. I'm going to stop here.
Johan, final word. I have to say Joachim, sorry.
Okay. Well, looking forward, I'd just say that the von der Leyen II commissions that took office last year has announced a number of big priorities on security, but also issues like quality jobs and a new approach to competition policy and taking into consideration, for example, global competition. But we think that also competition policy and quality jobs need to go hand in hand. And for that, we need, as I said earlier, also to look at broader than only the consumer interest test. We need more, in our view, a public interest test. How do we make sure that there are social conditionalities in place that do make sure that also competition policies contribute to good quality jobs? Because we need to use the whole toolbox, not only labor law, but also economic policies to strive towards these same goals. Because we think it's absolutely possible, including with the involvement of unions. So if we look at, for example, mergers, unions should also be involved in designing and setting the conditions to make sure that the potential monopsony powers are also indeed counterbalanced through remedies or collective bargaining.
Thanks. Arvid?
I think no poach agreements is the way forward because there is legal development in the EU at the moment. There was an opinion from the Advocate General in last month suggesting that no poach agreements could be by object infringement in Europe, like the per se infringement in the US. And yesterday, the Commission fined Delivery Hero and Glovo for a known poach agreement. So
that's your way forward then?
Yes.
Okay. Johan?
Well, think it's been a great discussion, and I mean, this subject with monopsony is where I started. It has become so much hotter the last few years among our members. I mean, as I said, from the beginning of the pandemic, the distance between our members' homes and their workplace has increased by 20%, and that they've been able to choose from much more employers, and we can see that has had a significant impact on their wages. So it is extremely important.
With these words, we give the panelists and Professor Marinescu a final applause. Thank you.